Court's recent inaction on the issue of gay marriage has ironically brought it to states that have banned it and left it banned in states that neither banned it nor permitted it. For more thoughts on how the courts are reshaping marriage in our country, we are joined by Richard Kelsey, Assistant Dean at George Mason University School of Law in Fairfax, Virginia. Mr. Kelsey, in some recent writings, you have made the case that the Constitution is silent on any right to marriage. So how is it that we have federal judges determining what will happen in different states?
It's a great question because I've not only made the case, but I've pointed out the fact that the Constitution is silent. The great thing about the Constitution is it's only about 6 pages long. You can flip through it. You don't have to be a lawyer. It wasn't written for lawyers. It is silent on the issue of marriage, gay marriage or any kind of marriage. That makes this a states' rights issue. So now you have essentially a series of challenges that believe that there's a 14th Amendment right that has sprung from the 14th Amendment that entitles people to a right to gay marriage or a federal right to marriage of any kind. I don't see that. It's not in the document, and you would have to essentially ignore the 10th Amendment in order to come to that conclusion.
The 10th Amendment, upholding the rights of states where it's not specifically saying that the federal government has the right.
That's exactly right. And people forget the 10th Amendment is part of our Bill of Rights. What it essentially stands for is if a right is not enumerated in the Constitution, and by the way, all the rights that the people have were not intended to be placed into the Constitution. They were reserved to the people through the states in the 10th Amendment. So really, this works out exactly how it's supposed to, which is the Constitution is silent. It then becomes a states' right issue. The states regulate marriage as they see fit, and that system has worked for as long as the Republic has stood.
So why do you think that the Supreme Court recently declined to take action on this issue?
Well, I think the Supreme Court, frankly, doesn't want to have anything to do with a hot-button issue that they, one, don't want to resolve, two, they're not entirely sure how it's going to be resolved, and three, they believe over the course of time, due to societal changes and attitude changes, that effectively gay marriage will become the norm, and they'd rather have that happen legislatively than through the courts. But now with the split in the circuits, it seems like they're going to have to actually do their job.
So going forward, do you think the Supreme Court will end up deciding and make a constitutional issue out of this, or do you think they'll end up declining and throwing it back on the states?
No, I think they'll take the case. I'm not much on making predictions, and usually when I make them, you can bet on the other side. But let's face it, they did not take the writ in the Fourth Circuit case, for example, because remember, you only need 4 justices to take the writ. And frankly, neither wing of that court was sure how Justice Kennedy was going to rule on this case. And so none of the 4 justices on either side wanted to take the writ. Now, the entirety of gay marriage, the breadth of the 14th Amendment, and the 10th Amendment may rest in the hands of one federal judge by the name of Justice Kennedy.
And I don't think any of us could have ever predicted that this all would happen. Mr. Kelsey, thanks so much for your time.
Thank you.